Hello, my name is Danya Palanker, and I'm Senior Counsel at the National Women's Law Center. This webinar is entitled, Am I a Large or Small Employer? Why is this question important? Under the Affordable Care Act, also called Obamacare, there are different rules that apply to large or small employers. Large employers will have to start offering coverage to all their full-time employees starting in 2015. Small employers do not have to offer coverage, but they are eligible to enroll through a new small business marketplace. So this webinar provides an overview of the rules to determine whether you fall into a small or a large employer. But many employers have complicated situations, and we recommend you confirm your status with your own legal counsel or benefit consultants. You may not be sure if you are a large or small employer under the law. The law's definitions may be different from how your state calculates the insurance market or what you actually consider yourself. A large employer has 50 or more full-time equivalent employees. Full-time under the health care law is 30 hours per week. Even if you do not consider an employee that works 30 hours a week to be full-time, that person is full-time for this calculation. Full-time equivalent is a way to calculate the hours worked of part-time workers into the total hours worked. For example, one full-time employee is one full-time equivalent. Two part-time employees that each work for 15 hours a week are also one full-time equivalent, because when you add those 15 hours together, they both together work 30 hours a week. The calculation is relatively simple. You take the number of employees that work 30 hours or more per week and add that to the total numbers worked divided by the total numbers worked by part-time employees divided by 30, and that equals the total number of FTEs, or full-time equivalents. Now, not every hour worked by an employee counts in this calculation. So what doesn't count? First, you do not count the hours worked by a full-time employee above 30 hours per week. So if an employee regularly works 40 hours a week, you do not count the additional 10 hours. Seasonal employees are not counted. Seasonal employees are not yet defined, but the IRS and Treasury rules have said that through at least 2014, so at least through this next year, employers are permitted to use a reasonable, good faith interpretation of the term seasonal employee for this purpose. So for example, if you have additional employees working for the summer because you have a camp type service that gets added onto your services, then those could very well be, the employees that are working the summer only could very well be seasonal employees. You also do not count a shareholder or partner unless they are paid as an employee. So what hours do count? First, you count the total hours worked in the prior calendar year. That means to determine if you have a responsibility to offer coverage in 2015, because you're trying to figure out if you're a large employer in 2015, you look at the actual hours that were worked in 2014. The employees counted are what is called common law employees, and that is a term which means employees that you, as the employer, control as to what will be done and how it will be done. You count employees in all members of a control group. What a control group is it's a term that applies if you have a parent company or related companies. Basically, if you're on your own as a one entity, you don't have to worry about this provision. But an example of a control group situation would be if there was a company called America's Social Services Company, and that company was the parent company of two subsidiaries, America's Child Care and America's Home Care. In that instance, the employees in both subsidiaries are counted in determining whether just one of the subsidiaries, say America's Child Care, is a large employer. So if America's Child Care has 30 full-time equivalent employees and America's Home Care has 40 full-time equivalent employees, then you add them together for 70, and that means you are both large employers. Now, there are many complicated issues that arise here. If you are at all unsure as to whether to count an employee, you should consider asking your legal counsel, accountant, or health benefits consultant. Thank you for listening to today's webinar. Please look at our other webinars available to help child care employers understand changes under the Affordable Care Act.